Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York, and in this video, I'm going to go over part 4, I think now, part 4 of my series about how to do a California divorce from the very beginning to the very end. So in past parts, I've gone over stuff about, for example, financial disclosures, the FL-142, how to prepare the petition, how to serve the petition, if you need to, how to take out a newspaper ad. And I've also gone over some kind of mindset tips, like basically the mental state about how to view the divorce, what's involved, how not to get discouraged, and so on. I'm hoping to make this whole series of videos a playlist. So go ahead and check my channel. I'll try to link the playlist up here if I can. But check my channel. Hopefully all these videos will come out kind of in series or in really close kind of proximity, so you shouldn't be struggling too much to find them, hopefully. So if that kind of makes sense to you, in this part, this is the first video where I think the steps involved, the stages involved are going to vary somewhat depending on what the other spouse does. So in a divorce, just think of it like this. If you're the party who files for the divorce, you're the petitioner, for example, you don't control all of it. Like basically the outcome of the divorce, how the divorce happens, the stages and so forth, they're going to depend on basically what you do and what your ex-spouse or soon-to-be ex-spouse does. So just know that, okay, you can't predict, you can't control everything. Your ex-spouse or your soon-to-be ex-spouse can't control everything either. So the two of you will determine what happens. So just know that you can't control or predict everything, I guess is what I'm trying to say. So because of that, this stage, I think stage 4 is what I'm at now. This stage will actually vary somewhat depending on what the respondent spouse, the other spouse in the case, does. So if you remember back to stage 2, I think is what I'm at now. Stage 2 goes over how to serve the petition, personal service, notice and acknowledgement by mail, stuff like that. So let's kind of pretend that you've done that, the spouse is served. Okay. The spouse, who is served, the respondent, has 30 calendar days from the date of service to decide what to do. So the thing is, at the end of the 30 days, if they want to file a response, they can. If they refuse to file a response or they don't respond to you at all, they don't kind of reach out to you and so forth to try to work things out, you can do something called a default case. I'll try to write that over here. Default cases are actually fairly common. They're not real complicated, but they're not complicated to do, but they can be complicated to sort of explain. I'm not going to go over default cases in this video, but in the future, if you want, I'll go put out another video on defaults specifically. But the important thing to remember here is that after the respondent spouse is served, there's a period of 30 days where you as the petitioner basically are kind of on the edge of your seat. You're not quite sure what the respondent's going to do, if anything. And depending on what they do or don't do, that will influence what you do as the next step, right? So hopefully that makes sense. So one possibility, like I just said, is that the respondent doesn't do anything. They don't file a case. It's been 30 days or 35 days or whatever, and no response has been filed. If you want to, you can file a default in that scenario. Finish the case on your own. If you're familiar with sports, and I think I know sports well enough to use this analogy properly. Imagine if you're like playing a game, for example, like a basketball game or a soccer game, football game, something, and your team shows up, but the other team doesn't. They just refuse to or something. So the thing is, that team oftentimes will lose the game by forfeit, and your team, because you're there, you would win by forfeit. So a default is not exactly the same thing as a forfeit, because a forfeit means you win automatically. A default doesn't mean that you win automatically. A default basically means that the other side, because they haven't shown up, they basically lose the right to participate in the case, I guess, if that makes sense. So that's kind of one scenario that happens. There's a whole bunch of other stuff that goes into a default. Like I said, I'm not going to go into it real in depth now, but a default is one possible scenario. The second scenario, which, I don't know, it really depends on what the respondent wants to do. But the second scenario is that the respondent might actually file a response. The response form in a divorce in California is the Judicial Council Form FL-120, FL-120, which I'll write over here. But the FL-120, like I said, you can also get it online for free as a PDF. You are supposed to be served with it if you're the respondent. The packet of papers that you're supposed to get served is supposed to include a blank FL-120 in it. But yeah, so the other scenario basically is that you as the respondent could file the FL-120. You could also, if you're the respondent, I guess, file a procedural challenge to say, oh, well, this county's wrong. We actually aren't married because of this, et cetera, et cetera. So, or you could say, well, we got divorced years ago. I did it on my own for whatever reason, et cetera. So those scenarios are not as common, but the most common two scenarios are, number one, the respondent files a response. The number two, and number two rather, the respondent doesn't file a response, in which case you can do a default. There are other kind of scenarios within the first one. So the respondent files a response, but they disagree with you or they agree with you, and so on. If you've ever heard the term contested versus uncontested, that's where that kind of is applicable. But the basic idea is going to be that, okay, depending on whether or not the respondent files a response, what you as the petitioner do may be different, or it might be, let me start that again. Depending on what the respondent's spouse does, your actions as a petitioner will vary. So the thing is, if there's a response, great, you got to deal with that. If there's no response, you got to go through the default process. So until the respondent does something, you as the petitioner, you have no idea which of these two is going to actually happen, right? So you got to make sure that you are kind of comfortable knowing that uncertainty. But so that's stage 4, I think. So it depends on what the respondent does. Stage 5, I'm going to try to go over stage 5 real quick as well. Stage 5, it's easy to explain. It is the most prolonged stage, I think, at least. So stage 5 basically is that you need to resolve whatever the outstanding issues are on your checklist. So at the very beginning, in part 1, I basically mentioned, okay, there's a checklist of items. Depending on the facts of your case, the items, some items might be included, some items not, and so on. So I think I used the example of, okay, if you guys have minor children under age 18, custody, visitation, child support, all that stuff will be on your checklist. So if we kind of imagine those, I guess, just children-specific checklist items, you need to resolve those checklist items somehow. I don't mean to use just children. It could be like alimony, property division, debt division, that kind of thing. Whatever the items are on your checklist, you need to resolve them somehow. So that's why I call it resolving the outstanding issues. So the most common ways to resolve the items on your checklist are, number 1, negotiate it somehow, negotiate a settlement somehow. And number two, take it to trial and have the court decide it. I think I mentioned that in part 1 also. But the vast majority of the time, long term, to come to an agreement that you can actually live with, long term, it is usually beneficial to try to settle it and negotiate something somehow. The reason I say that also is because, having done a lot of trials myself, it's something where, I guess, the time involved, the cost involved, the likelihood of success, the chance that the judge might not agree with your view of the case and decide something, and order something that you're okay with, but you're not really wild about, and so on. If you factor all of those considerations in together, taking it to trial, it's something that, trial is necessary in certain situations, but in the vast majority of cases, a lot of times people don't fully appreciate all the factors, the consequences, the expense, and so on of taking it to trial. Settlement in those cases generally is better. Long term, it's better for, financially for the client. It's better for, in terms of maintaining a relationship with the kids, so the kids don't hate them, blah, blah, blah. So, so basically, resolving the items on your checklist, negotiation, generally speaking, works out better for most people. In certain situations, negotiation is not possible, especially if you're in family court. The fact that you're there probably means that negotiation hopefully has been tried and, it doesn't work, etc. But, so the thing is, you have to negotiate it out somehow or take it to trial. In order to deal with all these issues, you actually have to be very specific about what the issues are, because issues can be within issues also, if that makes sense. I'll give you an example. So let's say that you do have minor children, and so your checklist includes, child support. To resolve child support, you guys could negotiate that out fairly quickly. You and the other parent could negotiate that out fairly quickly. Or there might be a fairly involved dispute about what precisely counts as income, right? You have some income from your job, but let's say that you're not a W-2 employee. Let's say that you're 1099, or you live off of your dividends, or you only work part-time, at a gig type job or something. So what exactly is, the proper income to use for child support? Is this parent who's working a gig job, for example, are they working to the best of their ability? So basically, any type of item on your checklist, child support, alimony, etc., you can always break it down into far more like specific, I guess, or more fine questions to have to answer. So for alimony, you could say, okay, well, is this person, is the spouse really in need of income? What's their health status? Can they work or not? And so on. So if your checklist, if you look at it and it's only like, 10 items, you go like, oh my God, hey, great, it's only 10 items. Those 10 items could in actuality be like 20 items or 30 items, depending on how it's parsed, I guess, if that makes sense. So that's why I say like this stage typically is the longest stage, the most kind of protracted stage, because there is a tremendous amount of work involved in negotiation, kind of in general. But if you're trying to negotiate something contentious between two parties who a lot of times may not like each other and so on, it takes a long time to work it all out, hopefully. So that's why I say stage 5, generally speaking, is the most involved, the most protracted. If you're kind of looking at your attorney's fees and how much you're spending and stuff, this I think is where you probably spend the majority of your attorney's fees. Because the attorneys have to talk back and forth, you might have to go to court to have the judge decide stuff, blah, 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 right? So that's stage 4 and stage 5. Hopefully that all makes sense. Let's go on to stage 6. I believe I should be able to finish this video in the next part. Because the remaining stages, once all of your issues are resolved, like once your checklist is resolved, it's actually fairly straightforward, fairly easy, I guess. But stage 5, like I said now several times, is that stage 5 is typically the most involved part, the most protracted part, the most time, the most energy. But if you can get past stage 5, generally speaking, the remaining stages are actually pretty simple. All right? So hopefully that made sense. I will see you in see you in the next video where I'll go over stage 6 and onward. All right? Thanks.